Hello everyone. So we'll continue our polity sessions for prelims, and we'll try to see what are the areas which are very important, which we should be revising, right? So let's focus. So let's start. Now, in the previous session and previous video, we have talked up until Sabrimala case, Indian Young Lawyers Association, Navdeep Johar, and all those stuff. We have done that. Now, today we'll talk about FD. So what is FD? That is fundamental duties, right? Fundamental duties, and this is a part of part 4A, right? Part 4 is for DPSP, part 4A is for fundamental duties. Now, it has been incorporated in the 42nd Amendment on Swaran Singh Committee recommendation. Remember, generally we get confused regarding Swaran Singh and Santhanam. Santhanam led to the formation of CVC, Santhanam Committee. Swaran Singh Committee led to the enactment of fundamental duties. Now, it is inspired by USSR Constitution and it is based on rule of jurisprudence. Again, they can ask you anything in prelims because we know how unpredictable prelims has become. So what is rule of jurisprudence? Rule of jurisprudence tells us that where there is a right, there must be a corresponding duty. Now 86th, earlier we had 10 FDs. 86th amendment added the 11th duty, right? Now remember, this is very important. This fundamental duties, they are applicable for citizens only, right? So they have been formed on the recommendations of Swaran Singh Committee. Santhanam Committee is about CVC, right? Now let's move on. Let's talk about federalism. Now, what does federalism in Indian context means? We do know what do you say? We are a quasi-federal state. There are different terms which are being said. That India is a quasi-federal state. What are the other terms which we say about like India? So the other term which we say is India is a what do you say? Federal state with a strong unitary bias, right? So under Article 1 of the Constitution, Indian states have no right to secede. They have no right to secede. The spelling is secede. That is, India is an indestructible union of destructible states. So indestructible union of destructible states. Now, see, SR Bombay is a very landmark judgment. So in SR Bombay judgment, what did happen? So in SR Bombay judgment of 1994, it was held that federalism is a basic feature of the constitution, or it is a part of the basic structure of the constitution. So remember, by SR Bombay judgment, we know that federalism is a basic feature. Similarly, you will see later on that by Minerva Mills judgment, we found out that judicial review is a part of the basic structure. So basic structure thing has evolved over the years, and we'll talk about more on post basic structure when we talk about GS2 portions of mains, right? When I will share the basic structure things. Now here also very good, like very renowned constitutional expert has said that if you're calling a certain part a basic structure, then what are the other parts? Are they non-basic in nature? Right. So it's a very fascinating thing. That's basic structure. We'll talk about it later on. So up until now, you have to understand that in federalism, India is an indestructible union of destructible states. Right. So states can be rearranged, can be what is fragmented, and all those things. But union is union. It is indestructible in nature in Indian context. Now let's talk about Union Territories Act 1963. Now why we are talking about Union Territories Act 1963? Because it's always in news because of Delhi and Puducherry. Whatever happens in Delhi and Puducherry. I don't know. I used to like the name Pondicherry, but fine, we'll work. What we can do, right? So under Section 44 of Union Territories Act 1963, the administrator has to act on ad and advice of COM, that is Council of Ministers. Now, so according to even if you don't remember the section, just remember according to Union Territories Act 1963, or even if you remember sections, well, very good, very good. So what you can do is when these questions comes on Delhi and Puducherry and all those things, Union Territories, devolution of power and everything, you can cite this even in mains. Now what you have to understand, administrator has to act and advise, but this is very important, there is a but here. At the same time, any difference of opinion between them, between whom, that is like, let's take an example like Kejriwal and the administrator of Delhi or lieutenant governor of Delhi, any difference between them can be referred to president, and in the meantime the administrator action prevails on any urgent matter. Are you understanding? So the administrator, the lieutenant governors, whatever he advised, that will prevail. So this gives clear edge to the center. So Section 44 is saying this. Now, in that regard, a judgment of Supreme Court also came, I think, in the last year. So you can go through it. National emergency and precedent suit, we have already done it in session 2. Do go through it. We have done a detailed parallel study and all those things. And there was Article 20. So Article 20 is, what do you say? Prevention in respect for conviction, right? There's also talk of double jeopardy in that you cannot be convicted for the same crime more than once, but there are again exceptions here. So all these things Article 20 talks about, and we have already discussed about this in session 2. So go through session 2 and you will see. And national emergency and precedent rules are important because they're a little tricky, dude. They're very little. If you do the parallel study, it becomes easier. Otherwise, if you're reading it in silos, na, it's a little tricky. So now let's talk about Rajbala versus state of Haryana. Again, these are all why we are reading Rajbala versus state of Haryana. So we were talking about Delhi later on, or Delhi and Puducherry. Now this is all about devolution of power and local bodies. Rajbala versus state of Haryana. If they ask you, Rajbala versus state of Haryana case dealt with what? Local body elections or whatever, or educational qualifications for local bodies, or it's related to state list, concurrent list, or whatever. So the thing is in Rajbala versus state of Haryana case, the the judgment was what do you say? The judgment upheld the validity of amendments to Haryana Panchayati Raj Act, which specified minimum educational qualification. So this was a very controversial thing: minimum educational qualification and access to toilet. So there were certain other conditions also that only if you have these things, then only you can what do you say? Fight for panchayat elections. Now the major issue was if there is no restriction for MP and all those things, why there's a restriction for local body election? Similarly, if you talk about local body more, 73rd and 74th Amendment inserted part 9 and 9A. So if they ask you, 9 and 9A deals with what? So they deals with local bodies, right? So they'll deal with local bodies. And this is a part of democratic decentralization, right? Aiyar Committee, again, this can be a very good question also. What does Aiyar Committee or dealt with, or Aiyar Committee refers to what, or Aiyar Committee was formed regarding what? So Aiyar Committee was formed regarding, or it was led by Shankar Aiyar. It was led for strengthening of PS or PRIs, that is Panchayati Raj institutions. So remember Aiyar Committee. Aiyar Committee is about strengthening, or they gave recommendations regarding strengthening of PRIs. Minerva Mills case. In the previous, what do you say, sheet in the previous page also, in the previous notes page, we have seen that as by SR Bombay, we saw that federalism is a part of basic structure. Similarly, by Minerva Mills, we saw that judicial review is a part of basic structure. Judicial review is a part of basic structure. Now, office of profit, again, they have given a direct question on these. This is again important, this office of profit scenario. So office of profit deals with what, or which particular articles in our constitution deals with office of profit? So article 102 and 191 deals with office of profit, but there is no specific definition. There's no specific definition of office of profit. Again, this office of profit thing has been explained in detail in second ARC ethics and governance report, where the report has also talked about office of profit in detail, and they have talked about how you have to specify, you need to have a proper definition for office of profit. So you can even go to my second ARC videos, or you can even see second ARC ethics and governance report. So that will also help in understanding. So remember, no specific definition of office of profit. Article 102 and 191 deals with office of profit, and this has been asked in the past in UPSC previous year prelims. So this is important. And later on you will see I have also added prelims related questions in my notes. So we'll discuss all the specific prelims related questions also. Now in the next video, in the next session, we'll talk about ADR, alternate dispute resolutions, right? So if you have seen the syllabus of GS paper 2, you have a specific topic which is talking about various organs, or what do you say, dispute redressal mechanisms and institutions. So this ADR portion will not only help you in your prelims, they can ask you anything right now. You do know that there's somewhat an overlap now. Prelims is becoming more and more unpredictable these days. So we'll talk about ADR in the next class, and we'll also see this whole thing will help you in mains also. Fine. So that's it for this session. So I will see you people in the next session. Thank you.